voters. Hey, if you're looking for something interesting to listen to when this program is over, may I suggest the Justice Tech Pros podcast? I love this podcast. I am hooked on this podcast. I wish every potential juror in this state and in this country would listen to this podcast. And I wish some of the prosecutors that have been a tad overzealous in certain federal prosecutions would get a clue and listen to this podcast. And I am thrilled that we have the host of this particular podcast on with us right now, Dominick Crea. Dominick, good morning. Thanks for jumping on the radio with me.
Good morning. Thank you again for having me on, Frank.
So, Dominick, for people that haven't heard our previous discussions, or for people that are a little slow on the draw and they haven't yet listened to the Justice Tech Pros podcast, inform folks who you are, what this podcast is, what sparked your desire to do it.
Basically, what I do is I have a litigation support firm, and what that means is we try to prepare and help and assist legal counsel prior to trial. So we do deal a lot with the e-discovery, getting things prepared in that fashion, going through the hard drives, anything to extract the information, extract the data, and make it nice and easy for counsel and for the firm that we're working with to prepare on their end so they could go through the materials and they have it in front of them. And with that said, back in November, I decided to put together a podcast after being part of my father was on a trial. And after being part of that and seeing
as a defendant, I want to make clear, not
correct.
An attorney. He was the defendant.
That is correct.
Right.
He was. I was working as part of the defense team, in support of his case, and unfortunately, things didn't pan out the way we wanted, and he was wrongfully convicted. So that kind of, long story short, that sparked me to start the podcast in an effort to enlighten potential jurors, to enlighten the public of things that take place, from a common sense perspective, just to kind of break down the various things that happen so people could relate to it and understand what goes on almost behind the scenes.
All right. Well, and you do a fine job. I've covered a number of federal trials, and I think you capture aspects of these trials that are usually overlooked by most in the mainstream press. So, Dominick, one of your more recent episodes, and by the way, if people want to listen to it, they can just search Justice Tech Pros on the YouTube. One of your more recent episodes focuses on New York discovery reform and how it might be needed on the federal level. Now, again, we have a lot of lawyers listening, but we also have a lot of laymen listening. Take us through this step by step. What is discovery? What is New York doing in discovery reform, and why do you think that's a good thing?
The discovery is basically the evidence that the opposition would have against the defendant, whether it's on the state side or on the federal side. When somebody gets indicted, you want to know exactly what they have against you and what you're going to be facing and what you're going to be fighting when the time comes to go to trial. So they call that discovery, and that's all the information that you could go through and understand where the case was built and whatever information that they have that could harm you, help you, whatever that may be. So with the discovery reform is made a change, and it went into effect January 1st of this year, which is a phenomenal change. It's actually a really positive thing that came to be, where you have a better time frame. On the federal level, just to give you a little compare contrast, they have what's called rolling discovery, where you start getting it in drips and drabs as your trial is going on and as you're preparing for trial. So you could get a bulk of information only a few weeks before trial, and it could be extensive data that you have to go through and you have to prepare. So what the reform has done on the New York side is they set a lot of aggressive timeframes where they have to turn over all the discovery within 15 days, and then they could get an extension, but the max is 45 days, and you'll have everything you need to prepare for trial. And also a huge advantage, you can't really go into plea negotiations until the discovery is turned over. Whereas prior, you could enter a plea and you don't have all the information against you. You don't know what you're up against, and then you have to make a decision whether or not to even take a plea. So any change in that respect, where it helps the defendant see, helps the defense team see what they're really up against, what kind of audio they may have, what kind of documentation they may have, is a benefit, and it kind of swings things in favor of the defense and makes things a little more even than they currently are now. And on the federal level, it's nowhere near that. It's a disaster right now.
All right, so let's talk about the federal level. And if people are just tuning in, we're talking with Dominick Crea from the Justice Tech Pros podcast. Now, there are a number of things New York does differently than the federal system. I've been a grand juror in New York State, for instance, and I can tell you grand jury proceedings are very different in New York State than they are on a federal level. What about the discovery rules? What does the federal system do, and why is it lacking in certain respects?
Well, right now, with the way it works is, the discovery could kind of be given and exposed as time goes by. There's no set timeline. So you could be indicted and your case doesn't go to trial for 3 years, and you could get remainder of discovery or the evidence that, the prosecution team has only a few weeks before trial. So now let's say there's something in there that you want to investigate. You may want to hire a PI, whatever it may be. You want to really look into in detail. You only have a few weeks to prepare for that when, in essence, you've been indicted for 3 years, and now you're just getting the information a few weeks before trial. So it really puts you behind the eight ball as far as trying to be prepared for trial. And you brought up the grand jury, which is, a huge aspect of it. In New York, you're entitled to the grand jury minutes, which is a big piece of the puzzle. You could see you want to make certain that whatever was said at the grand jury level matches to whatever discovery you received. And on the federal level, you can't get the grand jury minutes. You're not entitled to it. You could put in a motion to try to obtain them, but it's very rare and few and far between where that's granted, which to me, it doesn't make any sense. I mean, you would figure that would be a no-brainer. You want to see what was said at the grand jury matches what was given in the discovery and the evidence against you.
Yeah, you certainly would. And so this is exactly the kind of thing that people can learn about on the Justice Tech Pros podcast. Is there any sort of movement? Is there any proposal to change this at the federal system? Is there any realistic chance that this may actually happen, the discovery rules?
Yes, I mean, I know the NACDL has been working on justice reform on that level. So I'm hoping that that takes place, and that's the National Association of Defense Lawyers. And, they are pushing for it. So hopefully the same way New York has a new reform, which they just joined 46 other states. So now there's 45 other states. There's 46 total with the reform. So hopefully the feds will follow on the federal level.
One of the things in New York that was criticized a great deal as part of the same legislation where bail reform was passed was discovery reform. And one of the things that we heard from cops and prosecutors around the state was that this forces prosecutors to turn over not just the names of witnesses testifying against what some could be a violent criminal, but also their addresses. And this could potentially make witnesses reluctant to come forward if they were a witness to a crime because they don't want to be intimidated or threatened by somebody that they may be testifying against. Do you view that as a problem? Dominick? Well, I think Dominick's silence is saying a great deal about his answer to my question. So, no, I think he got disconnected. Oh, we got him back? Dominick, I have you?
Yeah, I'm here. Can you hear me all right?
I hear you, yes. Did you hear my question?
Yeah. I did.
Okay,
And I was just saying, I do understand the flip side of that coin. I understand what they're saying, but it's really, when you factor it in, it's more of just a time frame. Okay, so you don't get it now, you get it later on. But either way, when you look at it from the defense side, how could somebody not, face their accusers? If somebody's being accused of something, I think they have a right to know who's accusing them so they could kind of research it, see the validity to it, and see if it is something that is just a blatant lie or there's something to it, and strategize based on that. So, again, I understand what they're saying as far as, safety issues and concerns, but it's really just a matter of time. It's going to come out eventually. If they go to trial, it will be there eventually. So it's just giving it sooner rather than later, allowing the defense team to prepare.
Yeah. Well said, Dominick. Appreciate the time this morning. Let's do it again soon.
Absolutely. Thank you for having me on.
All right. It's Dominick Crea. You can check him out on the Justice Tech Pros podcast. Just go to the YouTube and just type Justice Tech Pros. It's the simplest way to get it. You can find it on all the platforms that podcasts are available. Search Justice Tech Pros. Hit subscribe. If you're interested in the criminal justice system, it is a must-listen experiment. Now,